The first case before us today is State of Ohio v. Becton. You will have up to 15 minutes to present your argument. Please stay behind the podium and keep your voice up because argument is being recorded. You should not use the names of children, minors, or victims during your presentation. You can refer to those people by general terms. We have read your brief and we are ready to proceed when you are. Okay.
Thank you, Your Honors. May it please the Court, Attorney Angie Killey on behalf of the appellant Nelson Becton. The issue that I would like to draw the Court's attention to today would be in assignments of error number 2 and 3 as they kind of co-work together a little bit. It is our position, and the question for the Court is whether Mr. Becton was denied his right to a trial by jury under both the state and federal constitutions by having a juror who was not qualified to serve pursuant to state statute. And we believe the answer to that question is yes. The Sixth Amendment has long required that there be trial by jury for all criminal defendants and that trial by jury include a unanimous verdict in order to support any type of a conviction in both state and federal courts. Our position is that it is not a unanimous verdict if those jurors are in fact not qualified to serve as jurors under law. Challenges for cause and qualifications are defined in the Ohio Revised Code under 2313-17, and one of those is that the juror be a resident of the county in which they are brought in to serve.
Counsel,
Yes.
excuse me for interrupting, but I realize that this goes into your third assignment of error in regard to the effective assistance of counsel. But I guess one of the questions I had when I was reading the briefs was, how do we know anything? Because I understand that's part of your argument that is ineffective, but nobody followed up. She said, I live in New Philadelphia, and that's it.
I know. I honestly, I'm not going to pretend like that didn't bother me when I was reading it because I was actually quite stunned that nobody in the courtroom noticed that kind of glaring, New Philadelphia is not in Summit County, Ohio, and did any type of additional voir dire. And because we don't have that information, it's our position that that goes to why it would be structural error, because it is difficult to impossible to determine whether or not, maybe she had just moved to New Philadelphia and she was a qualified juror, but that not knowing, in our opinion, should benefit the appellant. And he is the one who was convicted of a crime, and we don't know whether or not that jury was in fact what he was constitutionally entitled to.
And I understand your argument, but I guess going to the structural error part of it, I just am wondering, even with the structural error, how do we know that there was really a constitutional error? Or just that, first of all, I know there's the argument that it's statutory, not a constitutional error. But let's just assume it's a constitutional error. How do we know without knowing that she was or wasn't qualified?
Going down the hole on that one. Right out of the box. I suppose for certain we don't. And I think that's why in circumstances of structural error there is a presumption that if there is structural error found that it is an automatic reversal, because the denial or deprivation of that right goes to the very foundation of our criminal justice system and whether or not somebody got what they were constitutionally entitled to. And you're correct, I know the state makes the argument that it is not a constitutional error because the definition of what a qualified juror is a derivative of state statute. However, I would argue that that is flawed because every constitutional right that we have is further defined by statute and or case law. Therefore, that argument would indicate that we don't really have any constitutional rights that could ever rise to the level of structural error in order for the court to do a reversal. I know the state also focused a lot on the fact that the 12th, I think it was the 12th district, which of course is not binding on this court, had some issues come up with the qualifications of jurors and never did or do any type of an analysis under structural error. And in regards to that, our position would be, it's possible it wasn't raised, we didn't do an in-depth analysis, and obviously the appellate court's not going to review whether or not this does rise to the level of structural error if the attorneys on that case never brought it to their attention as such. And it also doesn't mean that you can't review it as whether or not it is a structural error.
I'm just wondering, wouldn't this be something that you could raise in post-conviction relief?
I don't know that I have a firm answer for that, but I suppose, I am no expert on post-conviction relief. But my understanding in the work that I have done in that area is that oftentimes if something can be raised to the appellate court and it is not, they won't consider it for post-conviction either. They'll say that this was the avenue, and that my position or opinion would be that because I did notice it, that this would be the most appropriate mechanism for having this reviewed and what kind of a deficiency it was or was not for the appellant.
Well, I just think it's fascinating because this is the first time I've had an issue like this in 25 years on the Court of Appeals bench. So I'm just thinking out loud, if you do post-conviction relief, you have to try to investigate where the juror is actually from and try to be able to submit an affidavit as to their actual residence at the time. And that might be a little difficult, I don't know.
I would agree with you. I think that it's something that could be feasible if an individual had the funds to do so, with hiring a private investigator to go out and review all of that information and submit it as new evidence to the court. However, we're dealing with an individual who is sitting in prison, serving what is now a life sentence, so he is clearly without funds and there is no right to have an investigator appointed in post-conviction in order to assist him with that. So, once again, my opinion would be that this is the appropriate mechanism, at least for initial review of whether or not it is. And I would share the court's position in my review. I have never seen it in all of the appeals that I have handled where something like this has come up. And although the prosecutor had some success finding some cases and some examples that weren't exactly the same issue of what the location of that juror was, they all seem to be in other jurisdictions. And I was unable to locate, doesn't mean it doesn't exist, but I didn't locate any in this jurisdiction. So I feel as though this is kind of a first impression for this court to be able to analyze, and I think that I firmly believe that it does rise to the level of a constitutional violation and would be structural error, because I can't see how we can possibly look into what different outcome there would have been if there was a different juror that was seated on that. And I feel like counsel's failure to object, or the entire courtroom's failure to recognize this issue, should not be a razor wave type of a situation. However, if it is, the court does have, if this court feels that it was waived as a result of the failure for it to be objected to, then I think that there's an argument to be made under plain error too, because this is an error, it's an obvious defect in the proceedings, unqualified juror, at least on its face. And the third prong for plain error is must affect substantial rights. I know that has traditionally been defined by the courts, is that it changed the outcome of the trial, which is of course where I find my difficulty and go back to structural error. But the counter argument would be the right to a jury trial is in fact a substantial right. And I think that maybe it could be expanded upon in that fashion. And if the court feels like none of that is applicable, then I would argue that it is per se an effective assistance of counsel. I know that that is usually a very high standard for the court to make a finding that somebody received an effective assistance of counsel under the Strickland prongs, because once again we start getting into positions of how it affected the outcome of the case, and I can't prove that, but I think understanding the qualifications of a juror, ensuring that somebody has a 12-member jury impaneled in a serious felony charge, to me, would indicate that they're below the standard of performance. And
I don't recall from your brief, and I take it you couldn't find any case law that discussed constitutionally the requirement that the jurors be from the same county.
No, I did not. Doesn't mean it doesn't exist, once again.
No,
I don't claim to be like,
I don't recall from your brief and don't recall seeing that.
If I had found it, I would have given it to you, but I didn't find anything contrary either. It was just kind of vague. I don't feel like this is something that comes up all that often. And my expectation is, as you know, outside as a practitioner, that's probably part of the reason why nobody noticed it, even though to me it was glaring in the transcript that this woman was out of county, because everybody just sort of assumes that when somebody's brought in, that they're a resident of the county because they're on the roster or however they actually do that. But I really think that this is a great case for the court to be able to analyze something that has not been reviewed under any type of a microscope in this jurisdiction, and we're gonna ask the court to find that it was structural error and to reverse and order a new trial for Mr. Becton based on that.
I was just thinking, I know that, you know, one of the notes I have is, you know, in regard to, do we have some presumptions here? A presumption of residency since they were, you know, pulled from the roster of residents in Summit County. And the thing is, we just don't know, I guess, in a file, there's nothing that indicates like any, you know, how they do the biographical sheets and stuff. If she put down New Philadelphia there, or
No.
okay.
No, unfortunately, it's just silent as to all of that, which makes it a little bit trickier, I agree, but once again, I think that those issues should weigh in favor of the appellant because of the seriousness of this right that's potentially being affected by what happened.
By the way, New Philadelphia is a nice area, that's where I'm from.
It is a nice area, it's
That's
Tuscarawas
Horace
County,
County.
and I've been there, that's probably why I noticed it so quickly, but
Yeah. Definitely, I would have noticed it only because I'd be like, New Philadelphia. Okay.
if the court doesn't have any other questions in regard, the rest of it, I would rest on my brief. Okay, thank you very much.
Thank you very much for your presentation. The court will take the matter under advisement and issue a decision in due course. You will receive a copy from that from the clerk of courts on the day that it is released. It will be mailed to you. The opinions are also posted on the Ohio Supreme Court website.
Thank you.
Thank you.